Sure.
Hi, hope you had a pleasant journey today. Please take a seat.
Okay. Please give me a second. I want to reply some emails.
So what can I do for you?
Just give me a minute. Wait a minute. Where's your managing partner? I thought a professional would be handling a client like me.
Oh, I assure you, I am more than capable of handling any legal issues that you might have. Can I get you something to drink?
Fine, whatever. Let's get straight to business. Those badges are stealing us over our weight killer products, you know? They are feeding some respiratory diseases garbage.
I'm so sorry to hear that. Class actions can be bad publicity for any company.
Anyways, these reports contain internal clinical trials incriminating my products, and we must not let them get out.
You have nothing to worry about. Everything that you give to us is bound by lawyer-client confidentiality.
Speaking of which, my other lawyer friends told me about the client legal privilege at the golf course on Sunday. I want to make sure that this evidence cannot be submitted to the court in discovery. Also, I'm going to destroy the originals just to be safe.
Sure. Let me get back to you. How about check with Louise, and in the meantime, we'll reschedule a meeting for Friday.
Fine, just make it quick.
If you don't mind me asking, did you know about any problems with the product beforehand?
Of course I know. I'm bloody good at my job. I want somebody here. I know everything that goes on in my company, and if you know what's good for you, you won't tell anyone about this.
Of course. It's just so that I've got all the bases covered. I'll see you on Friday.
Okay, do your job and just don't keep me waiting. I know you have problems with cash flow and need the money. Do as you are told and everyone wins. Okay?
See you later.
See you.
This doesn't seem right. Let me see what I can find. Fiona Gotzel on behavioural legal ethics.
Hi, and welcome to Behavioural Ethics in the Professional Context. Hi, and welcome to Behavioural Ethics in the Professional Context. I'm Fiona Gotzel, and today we take a deep dive into client legal privilege, or CLP. As a solicitor, how would you handle a scenario where a client wanted you to abuse CLP? Viewers may be familiar with Reston Breaky's moral process. Let's take a look. Let's say our client asks to hide incriminating evidence behind CLP. They may even want you to destroy the documents. Stage 1, our solicitor needs awareness of the morally salient features. Our solicitor may have a general awareness of the classes of situations covered by the professional codes, which require morally salient features. However, our solicitor may also have a specific awareness of the morally salient features that are specific to their circumstances here and now. Under specific awareness, our solicitor may use qualities like perception and curiosity to question the client's underlying motives for claiming CLP. Is this really for the dominant purpose of seeking legal advice, or something more sinister? However, in stage 1, our solicitor may face ethical blindness from the framing of the issue. I'm just taking my client's instructions. It's just business, right? Wrong. Stage 2 is judgment, where our solicitor requires moral reflectiveness. He must use his cognitive capabilities to apply critical thinking and apply the professional codes correctly. For example, he may realise that the destruction of incriminating evidence does probably not fall under the dominant purpose test. However, he may also face challenges in applying the Australian Solicitors Conduct Rules, Rule 9.2.3, in that a slow-acting respiratory disease may not be imminent enough to permit disclosure of confidential information, as an example. However, at this stage, the solicitor must be careful not to replace his moral process with other types of normative thinking. For example, the misplaced sense of loyalty that a junior solicitor might have to his employer. At stage 3, decision-making requires moral motives. Our solicitor must realise that if all solicitors follow the codes of professional practice, this gives rise to a standard of excellence. Isn't that notion of status, dignity and honour the role that he desires? However, at this stage, David Laban warns against cognitive dissonance, allowing our solicitor to inflate his sense of loyalty to the client. Stage 4, and where's your moral character? In order to take action, you need virtues like courage to stand up to the client, perseverance when the client threatens to take his business elsewhere, and compassion for the future diseased victims that could be hurt by abusing CLP. Stage 5, achievement. Well done. I'm assuming you had the moral competence to successfully implement your moral decisions and achieve your moral goals, setting firm boundaries with the client, informing them of the limits of CLP, and ideally not destroying legal evidence, which would be the commission of a criminal offence. If not, it was no doubt due to your lack of experience as a junior solicitor, being in an unfamiliar situation. Stage 6, review. Now our solicitor has a chance, away from the pressures of the moment, to once again utilise moral reflectiveness. Does he have a new perspective? Or is he simply going to rely on the same rationalisations to justify his behaviour? Oh, I was just taking my client's instructions. Oh, my financial situation means that I can't afford to lose a client. Oh, I'm too inexperienced to make decisions. I'm just going to let my principal handle it. The choice is yours. Thanks again for watching Behavioural Ethics in the Professional Context. I'm Fiona Godsall. Have a great day. Come in.
I'm terribly sorry to disturb you in the day off. I'm just having some concerns with the Mackenzie group.
What do you mean concerns? Rodney is one of our best clients. We better not have done anything to jeopardise our business.
No, nothing like that. The conference went ahead as scheduled earlier today, but he asked me to do some things I'm just not comfortable with.
I knew I shouldn't have given you more responsibility. Anyways, explain yourself.
So as you're aware, Rodney's company is the subject of a class action for a weed killer chemical causing respiratory disease. He wants us to claim client legal privilege for the incriminating reports, showing his firm already knew of the negative effects ahead of time. He also confessed his guilt and informed me that he intended to destroy those documents. Luckily, we've still got some backup copies.
Just do whatever it takes to make him happy. The client's documents are protected under subsection 118 and 119 of the Evidence Act, which, if you know how to read, includes contents of confidential documents prepared for legal advice or litigation.
Yep, that sounds right, but don't those sections say something about dominant purpose? I know that's a lower threshold than the sole purpose test, which courts used to apply, but it seems like Rodney just wants us to cover his tracks, and the contents of those documents were not prepared for the requisite purpose.
It doesn't matter. Section 117 defines client to mean a person or body who engages a lawyer to provide legal services, and this includes employees or agents of the client. Therefore, CLP must be absolute.
Surely that can't be right. There are so many exceptions within the Evidence Act, such as 121, inconsistency with Australian court orders and rights of the person. 122, consent and acting in a way inconsistent with the maintaining of privilege. Not to mention, 125 contains an exception for misconduct, meaning communications made or documents prepared in furtherance of the commission of a fraud or offence.
Great. I suppose you're going to tell me about the solicitor's rules next.
Oh yeah, I was just getting to that. Rule 9.2 largely echoes exceptions within the Evidence Act, and the most important one for our present purposes is Rule 9.2.4, which permits disclosure for the probable commission of a serious criminal offence.
9.2 clearly says a solicitor may disclose information. You're not forced to under any circumstances. I'm permitted to. Doesn't mean that it's a good idea.
I'm not so sure about that. Following the McCabe tobacco case, it's clear that 9.2.4 applies to document destruction.
What about your duty to your client? Following instructions under Rule 8.1 or acting in the best interests? 4.1.1.
I think you're forgetting lawful, proper, and competent. Not to mention, we're not allowed to act as the mere mouthpiece of the client. As you should be well aware, our duty to the court and administration is paramount, superseding all other duties when inconsistent.
Okay, fine. You win this round. But there are very good reasons why CLP should be given the broadest application possible. Justice Dean and Attorney General Anne Marie said that its efficacy as a bulwark against tyranny and oppression depends on the confidence of the community that will be in fact enforced. That being so, it is not to be sacrificed even to promote the search for justice or truth in the individual case or matter.
I think my position on the matter is similar to Stella Bock. While I agree CLP is essential for the functioning of our justice system, it should only extend as far as necessary, and in any case, that cannot override greater injustice. Unmerited claims would only undermine the rule as a whole, and as solicitors, we must hold the line.
Well, you know what? I'm the boss, you're the employee. You do what you're told.
Yeah, well, the International Bar Association tells me lawyers should still act on the dictates of their conscience. This isn't right.
I don't pay you to act on the dictates of your conscience.
Hi Ronnie, thanks for coming in again today.
I want to hear some good news.
Unfortunately, I have some bad news. Those reports you disclosed to us are not covered under CLP. You should also know that destroying evidence is a criminal offence. I would strongly advise against this. Finally, take a good hard look in the mirror. You're killing people, man.
Really? So,
Well, that's a wrap. Thanks guys for watching. I don't know about you, but I was personally really pleased that Sam decided to act on his values. What about you?
Yeah, I think so too. You know, it's always good to be true to yourself.
Yeah, exactly. Although it was still really difficult for him, wasn't it?
Yeah, one of Sam's disablers was his uncertainty of the professional codes, what constitutes an imminent serious physical harm under Rule 9.2.5, you know, would the slow fatal effects of Rodney's weed kill count as imminent?
Well, Parker and Evans argue that more certainty would empower lawyers to act in accordance with the professional codes. I think Sam would have been more confident about his decision if he knew for certain that Rule 9.2.5 applied.
On the other hand though, the words may disclose means Sam was still challenged by another disabler.
Oh yeah, the breadth of the dominant purpose test made it really difficult for him to distinguish between what's a legitimate case of client legal privilege and what's an abuse of privilege.
I heard the Australian Law Reform Council recommends better legal education and general enforcement of the existing standards of CLP by courts and regulators, rather than specific penalties for abuse of privilege. However, this still leaves open the problem with assessing an abuse of privilege.
You know, I like the idea of fully disclosing evidence at the start of trials. This policy is increasingly being adopted in civil and family trials. It's cheaper, it's fairer, and it's more efficient.
But doesn't that undermine the general public interest value in confidentiality?
Perhaps, but William Simon argues that there's less public interest when big corporations in defined antisocial sectors are involved. These just foster a culture of zealous advocacy for the client, which undermines ethical principles of honesty and integrity.
That was another one of Sam's disablers. He was under so much pressure from the client, who was very wealthy, and Louise also really pushed him to follow Rodney's improper instructions. It'd be very difficult for most solicitors to act in line with their ethics.
Well, maybe CLP shouldn't apply to litigation involving these big corporations.
Another disabler was that Sam was unsure of what course of action would be in the best interest of the public, and whether he really does owe confidentiality to the client.
Reston Breakey's ethic regime can show that institutional supports can empower solicitors to act not only in accordance with professional codes, but also in the best interest of the public. Sam's workplace should have encouraged him to seek advice from legal professional ethics advisors outside of the firm.
And I think that should be further reinforced by federal regulatory bodies, just to be safe. Stay tuned for part 2.
Part 2? There's no part 2. Thank you.